Good morning. My name is Craig Birchie, and I'm a partner with the law firm of Kilpatrick, Townsend, and Stockton in Atlanta, Georgia. And a few months ago, I was asked by the Pro Bono Partnership of Atlanta to offer a webcast to you on Fair Credit Reporting Act compliance with a specific focus on employment background screening, both pre-employment background screening and screening during the term of an employee or volunteer's employment. Before we get to the substance of the slides and the presentation, there are a few administrative matters we have to take care of and a couple of administrative announcements. The first slide up here is the mission of the Pro Bono Partnership of Atlanta, which is to maximize the impact of pro bono engagement by connecting a network of attorneys with nonprofits in need of free business legal services. And in order to be a client of the Pro Bono Partnership of Atlanta, you have to meet the requirements listed on this slide. Be a 501c3 nonprofit organization, be located in or serve the greater Atlanta area, serve low-income or disadvantaged individuals, and be unable to afford legal services. If you're interested in joining the Pro Bono Partnership of Atlanta, the information regarding joining is here on this slide, slide number 3. And there's an email address that you can, where you can get further information. Finally, the disclaimer that comes with these. This webcast presents general guidelines for Georgia nonprofit organizations and should not be construed as legal advice. Always consult an attorney to address your particular situation. So with those sort of preliminary matters, let's get into the substance of the web now. What I like to do when I give this presentation is to just give an overview of what we're going to talk about so that you'll have an idea of where we're going and decide if this is of interest to you. So the 3 topics we're going to cover is, do I or does my organization have to comply with the Fair Credit Reporting Act? Who is protected by the Act? The Fair Credit Reporting Act, as we'll see, is a consumer protection statute. And so it may be counterintuitive that it applies in an employment context or in a volunteer context, but it does. So who is protected is an issue we'll cover. And then finally, we'll address some basic issues for compliance. And that's going to be, the sort of the overview of our presentation today. So the first issue, do I have to comply with the Fair Credit Reporting Act? And the short answer is yes. The Fair Credit Reporting Act is one of those statutes that could not be more inaptly named. When people hear that phrase or they hear about the statute, what they think of is their credit report and the dealings that they're going to have with credit reporting agencies like Equifax, TransUnion, or Experian, and they think of credit reporting. But the fact is, the statute itself applies to something broader. The language of the statute applies to consumer reports. I'm going to read you the definition of that phrase as it's found in the statute, and you'll see just how broad it is. This from the statute. The term consumer report means any written, oral, or other communication of any information by a consumer reporting agency bearing on a consumer's creditworthiness, credit standing, credit capacity, those you would all expect. Here's where it gets really broad. Has a bearing on a consumer's character, general reputation, personal characteristics, or mode of living, which is used or expected to be used for the purpose of employment. So you can see the definition of consumer report starts out fairly focusing on credit issues. Then it gets really broad and it begins talking about these things like mode of living or personal characteristics. And frankly, it's hard to think of something I could tell you about a consumer that wouldn't be covered by those things. It applies really to almost everything, and in particularly to someone's criminal history. So the definition is very broad, and so if you're running criminal background checks on your current employees or on prospective employees or even on volunteers, and we'll talk about that in a minute, you're going to have to comply with the statute. So that's our first issue. Second issue is who's protected by the FCRA. There's no question if you read the definition of consumer report that's found in the statute that it's going to cover current employees and job applicants. So if you have someone that you are paying who is a W-2 employee, that person's going to be protected by the Fair Credit Reporting Act, and anytime you run a criminal background check on that person, you're going to have to comply with the statute. What may not be as intuitive is whether or not it applies to people who are not technically employees. For many years, I think the courts, as well as a lot of employers, took a very narrow view of the statute. And what they said is, if someone is a volunteer, if they're an independent contractor, if they don't meet the technical term of a W-2 employee, then I don't have to comply with the statute. And that's in fact false. There have been not, I guess, court decisions, but also regulatory guidance from the Federal Trade Commission on this issue. And what that guidance says is that the statute should be construed broadly to serve a remedial purpose. That's the FTC's language. And so the protections of the Fair Credit Reporting Act extend to independent contractors and volunteers as well. So I know a lot of you are probably, not only do you have people who would be considered employees, you're also using volunteers, and if you're running a background check on them, you need to comply with the Fair Credit Reporting Act. It's just as simple as that. You don't want to be the one to be a test case on that, or to take that to court, because frankly it's just not worth the legal fees it would take. It's a lot easier to just go ahead and comply with the statute. So with that in mind, let's really get to the substance of this. I mean, if you have to comply, what do you have to do to comply? And the next slide here is just your overview for compliance. Essentially 5 things you're going to need to do. You're going to need to obtain a disclosure, or you're going to need to disclose to the prospective employee or volunteer or current employee that you're going to obtain a background check on them. You need to get their authorization to do so. You can't just do this on your own or without their authorization. Then if you get a hit, you're going to have to give them pre-adverse action notice. That means before you fire them or decide not to hire them, you're going to have to give them notice that you're considering doing that. You then have to wait, and then a period of time, generally 5 days to a week, to give them time to any inaccuracies on their report, and then finally you have to give them post-adverse action notice. So that's sort of a overview of what the requirements of the statute are. Let me now break that down and talk about the specifics. So the slide that you have up now should be one that says the disclosure requirement. That's the one we should all be looking at. And probably the best way to think about the disclosure requirement is don't hide it in the fine print. Many times you've probably seen, whether it's a credit application or an employment application, you'll see the page of fine print where all the terms and conditions are buried. When Congress passed the Fair Credit Reporting Act, they said, with respect to this particular issue, we don't want you to hide the information. If you're going to obtain a criminal background check on a prospective employee or a current employee, we want you to go ahead and disclose it to them in a way that is conspicuous and obvious. So the first bullet point here, the employer must give the applicant a clear and conspicuous disclosure. And so don't put it in a tiny font, don't bury it on the back page, don't bury it in with other terms and conditions. The disclosure has to be in writing, right? I mean, and that's really for your protection as well. You wouldn't want there to be a dispute or a swearing match as to whether or not an oral disclosure was given. So make sure the disclosure is always in writing. The disclosure has to be in a document that consists solely of the disclosure. Now this is one that, again, the idea is let's not bury the disclosure in with a lot of other terms and conditions. If you've got a multi-page employment application, then that disclosure needs to be on a single page. And if you're doing an online or electronic type application, just make sure it's on a separate screen, so you're not hiding it in with other things or burying it. And finally, the disclosure has to be given before the background check is obtained, so you can't do it essentially in arrears. You can't go ahead and obtain the report and then later give people notice that you had done it. You need to do it before you get the report. And the next couple of pages or the next couple of slides are examples of what I consider to be disclosures that are either non-compliant with the statute or those where the compliance is questionable at best. So the first one here, and I apologize for the small print. That's in part my fault for the way it was blown up, and in part the disclosur's fault for using this fine print. But this is exactly what Congress was trying to avoid when it drafted the Fair Credit Reporting Act and put in the disclosure requirements. So what you have here is what purports to be a consumer report, investigative consumer report disclosure. And if you read the first paragraph, there's a disclosure. The employer here is saying that they will obtain a consumer report, or what we call an ICR, investigative consumer report, on the subject. However, there is a lot of other stuff that's thrown in here. You've got state law disclosures, and interestingly enough, you have, and this is what I think really makes this particular example defective, you've got a liability release. If you look down under the section, again, the print is very small, entitled Authorization for Release of Information, about halfway through that first paragraph it says, as permitted by law, I fully release blank and suppliers from all claims and damages related to investigation of my background. So to include a release of liability in with a disclosure that is to consist solely of the disclosure, I think clearly violates the statute. And the problem that this creates is not just if you've got a single employee you're doing this for. The problem is you've now set yourself up for a class action lawsuit. Because what happens is a lot of people have standardized employment and hiring procedures. This defective disclosure is now given to everyone who an employer would run a criminal background check on, and is going to set them up for liability in every instance. Because the Fair Credit Reporting Act is a consumer protection statute, it has statutory damages, and it's basically a $1,000 penalty to every employee or prospective employee this defective disclosure went out to. So the numbers can get big very quick. It's important that, I guess the bottom line here is it's important that you not stumble over this low hurdle. It's easy to have a disclosure that meets the requirements of the statute. Don't trip over this very low hurdle. The next page, another disclosure that is, this one probably, compliance is a little more questionable on this disclosure. It's a little cleaner than the previous one in that it seems to only contain a disclosure and authorization. However, we've got some state law information here for California residents only. Probably the better practice would be to take state law disclosures out of this particular one and put those on a separate page of your application, or again, if you're electronically, just put it on a separate screen, so that way you're not mixing state law disclosures with your federally required disclosure. All right, that one, real law on that issue, but it's just one that I think it's easy to comply and easy to put the state law disclosures on another page. So again, the takeaway is the FCRA disclosure. All right. Yep.
What if you get the information from a reporting agency that you work with that conducts background checks, and you're using a company, and they give you their authorization form?
Check it. The requirement to authorize, the requirement to do disclosure and authorization is put on the end user of the report, not on the consumer reporting agency or the background screening company. So if you're using their form and their form is defective, you're the one who's going to be liable. So you've got to independently assess this issue. And I know most of you do, and you've raised an important point. Let me make one thing clear. The Fair Credit Reporting Act applies when you are purchasing a background report from a company that does this, that in the regular course of their business conducts criminal background searches and does it for pay. There's nothing in the Fair Credit Reporting Act that prohibits an employer from doing its own investigation of someone's background. So if you have an HR department and the HR department calls up a landlord for references, or conducts its own investigation. I mean, if you were to send your own HR personnel down to the courthouse to look at criminal records, that would be fine. You wouldn't be covered by the Fair Credit Reporting Act. The Fair Credit Reporting Act only applies when what's called a consumer reporting agency, for your purposes, a background screening company, does the reporting. That's the hook. But thank you. Point one is you've got to make the disclosure and tell the prospective employee and or current employee that you're going to run a criminal background check on them. Secondly, you have to get their permission. You can't just do this, go to a credit reporting agency or background screener and order a background check on someone without getting their permission first. And so that's what we call the authorization requirement. So the authorization from the consumer needs to be in writing, or the job applicant needs to be in writing. The authorization is sort of this one exception to the rule that the disclosure must consist solely of the disclosure. So a disclosure can also include an authorization. On the same page, whether it's in writing or it's a screen capture electronically, you can disclose to the consumer or the job applicant, I'm going to run a background check on you, or I'm going to obtain a criminal record search on you, and then also include a signature line for their authorization. I authorize you to do it. So if you go back one slide to this disclosure we were looking at, they have the disclosure in the top part and the authorization in the bottom part. That's okay. It's okay to include an authorization with the disclosure, but that's really the one exception to the rule. You can also obtain a blanket authorization. So a lot of companies or employers, they not only run a criminal background check on their job applicants at the time of the application, but they'll also run criminal background checks on their employees periodically at 1 year or at 5 years, or when they're being considered for a promotion, or their job responsibilities are changing and they're going to have access to cash or pharmaceuticals or something else that be of value. A lot of employers will then run a follow-up background check. The authorization can be what we call a blanket authorization, so it would not only authorize the employer to obtain a criminal background check in the first instance, when in connection with the job application, but would allow the employer to obtain a background check going forward or during the term of the employee's employment. If you're going to have an electronic application, not sure if you do or not, you need to comply with the e-sign law. The e-sign law probably beyond the scope of this presentation, but if you've got an electronic, we can do that next month.
No, so it's being done next month.
Oh, great. Well, that's fantastic. It's being done next month, apparently. That would be a good one to tune into, because if you've got an electronic application, you've got to make sure that you jump through certain hoops in the e-sign law in order to get the consumer or the job applicant's authorization. All right. So then what happens, and let's advance the slide now to pre-adverse action notice. So what happens if you get a hit? You've got a prospective employee, you really want to hire this person, you run a criminal background check on them, but you get a hit. They come back with some sort of criminal history that would be disabling and would result in them not being able to get the job. Well, before you make a decision that you are not going to hire this person, you've got to give them what the law calls pre-adverse action notice. You can't just call them in and immediately say, you know what, you didn't get the job, or send them a letter and say, sorry, based on your criminal history, we're not going to be able to give you a job. You've got to give them notice before you actually make that decision. That's called pre-adverse action notice, and included with it is a copy of the background report or the background check, along with a summary of that job applicant's rights under the Fair Credit Reporting Act. The obvious purpose of this is to let people try and correct errors. The problem that a lot of consumer reporting agencies and background check companies run into is the matching logic that they have, their ability to associate a criminal record with a particular consumer or job applicant is not real good. If you go down to the courthouse and begin searching the criminal records, a lot of the records are not going to have the convicted person's middle name. You're not going to get a social security number. You're not going to get previous addresses. In a lot of instances, you're just going to get a name and a date. Maybe you'll get a date of birth if you're lucky. And because remember, we're dealing with a patchwork of court systems all over the country. You've got state, county level courts, and they don't all keep records the same way. And so if you have someone who has a common last name, John Smith, and how many John Smiths would there be in DeKalb County or Fulton County? You're going to get a lot of them, and it's going to be hard to necessarily know that the person who wants a job with you is the same person who's got this conviction. So the idea is you tell them, here's a copy of the report, is this correct? And you give them an opportunity to correct it. And that's the whole purpose of the pre-adverse action notice. You need essentially a cooling off period. Why don't we advance the slide to the next one, the waiting period. So before taking adverse action, the law actually requires that the prospective employer wait, quote, a reasonable, close quote, period of time before making a decision whether or not to hire the person. Again, the purpose is to allow the job applicant or the employee to challenge the accuracy or inaccuracy of the report. And what is reasonable under these circumstances really varies. I'm not aware of any FTC guidance on the issue, but 5 days from the court cases seems to be the sort of the bare minimum you can wait. If you could wait 10 days or 2 weeks, that probably would be better. Again, give the person a chance to clear up the error, and that'll be that you won't have any problem with compliance if you wait. So let's advance to the final slide. So let's assume that either the report was accurate or the applicant has not had a chance to clear up the error. You've decided you're not going to wait around and hire them. You have to give, and you're not going to hire them. You now have to give what the law calls post-adverse action notice. And the requirements for the post-adverse action notice are you have to give the name, address, and telephone number of the background screening company that produced the report. Why is that? So the prospective employee can call them up and try and get the matter fixed or get it corrected if there's still an inaccuracy. You have to include a statement that the consumer reporting agency, that's the background screening company, did not make the decision to take the adverse action. Why is that? Because you don't want, the purpose of the statute wasn't to have the employee or prospective employee call up the background screening company and complain to them about not getting the job. The only issue that should be addressed with the background screening company is the accuracy of their report. Whether or not the person was hired or whether or not they got fired after they had been there for some period of time, that's an issue that needs to be dealt with through the employer. And then finally, another notice of the applicant's rights under the Fair Credit Reporting Act. That summary of rights is very important, and it's now prescribed by law. The CFPB, which is the Consumer Financial Protection Bureau, the new consumer watchdog agency that is part of the new securities law, that is, they have prescribed a form for compliance with this section of the statute. They actually have a form summary of rights under the FCRA. If you go to the CFPB's website, you can download it there. So again, just to recap, if you're in this business and you're going to have to comply with the FCRA, it's disclosure, authorization, pre-adverse action, wait, and then post-adverse action. 5 requirements. All right? And
Question?
all right?
Could repeat it?
Sure.
We utilize. We utilize the local sheriff's office as well as GAPS fingerprinting, not a background check company. Does this fall under the FCRA requirements?
I guess I would need to know more about the entity that you just mentioned, the fingerprinting company. I mean, if that was If the fingerprinting company was a third party, a private business that was engaged in this for profit, then they would be considered a consumer reporting agency under the statute, and you would need to comply if you were relying on their reports. The law does not identify public entities like courts or police officers or other governmental entities as consumer reporting agencies. So information that you obtain directly from them would not be covered by the statute.
Another question. If I ask my volunteers to go to a police station to get their own background check to provide it to my organization, is that okay?
Yeah, you would not be using so the question, to repeat it again, is if we had a volunteer essentially self-report their criminal history, go to a police station or go to some other, I guess the clerk of court, to get a printout of their criminal history. In that circumstance, you're not using a consumer reporting agency or a background screening company and would not be subject to the statute. You're just having them self-report. It would be analogous to, let's say you had a section on your job application employment application where the employee was required to list any previous convictions they had. That's really all you're doing there. And again, a government entity like a clerk of court or a sheriff's office, those are not considered under the statute to be consumer reporting agencies. All right, thank you very much.